Okay. All right. So we are now recording. And I am going to share my screen and we're going to start our session. Let me just move all this stuff out of there. Okay, perfect. Hi, everybody. Welcome to Demystifying Copyright, a friendly guide for artists, a foundational online workshop about art, copyright, and licensing. Um, One thing I forgot to mention is that I have two screens. The one that is has Zoom, and then the other that actually has my slides. So I wanted to give that FYI in case I come back on the screen or you see me now and you're like, where is Kate looking? She's looking to her left. She's looking to her right. Just wanted to give you that for your information. So anyway, welcome to the workshop. And what are we going to be learning? Why are we here today? So we're here today because you all want to understand the basics of copyright in a very clear, practical way that you can use and relate to your art making. You don't need any legal background to be able to do this. In this workshop, we're going to be translating some pretty complex topics into what I hope are going to be simple, actionable steps that make your creative practice have even more confidence behind it. So who am I? I'm your instructor for the next 2 hours. My name is Kate Thornhill. I work at the University of Oregon. I'm a librarian who specializes in essentially all things digital and data as it relates to anyone who works in the visual arts, the humanities, and any kind of social science based, like learning about how humans navigate and tell stories around the world and in different cultural contexts. But pretty much you can think of me as the librarian who really knows how to use the internet and create images, videos, podcasts, ebooks, websites. I'm your go-to. What that also means is because I prioritize access and archiving, I also am a specialist in copyright education. I'm not a lawyer, and I say that pretty strongly that I'm not a lawyer, and never do I give any legal advice. I am just an educator and an advocate around everyday folks like ourselves learning about their intellectual property rights as it relates to being a US citizen. So again, I specialize in intellectual property rights, online publishing, access to research, and information communication technologies in general. What that means is like, you want to know how to use Instagram? I got you. I can teach you how to use Instagram. You want to know how to use X, formerly known as Twitter? I got you. I can teach you how to use that as well. But does my work how do I relate to the visual arts? Well, I'm a ceramicist. I own my own ceramics business. I'm from Eugene. I work out of Eugene. I'm also an art educator and teaching artist at Maud Curran's Art Center. I teach the kids clay classes. And in a past life, many, many moons ago, I used to be an art librarian in Massachusetts. So let's go over our workshop structure. How are things going to operate? So what we're going to learn today is what to expect. What exactly is copyright and what does it mean for you as an artist? And it's much simpler than you think. You're going to also identify clear ways to share your work while keeping your rights protected. And also you're going to gain some straightforward steps to safeguard and protect your art in the digital world. Our workshop is going to be 2 hours long. There will be 10-minute breaks throughout this experience. And I also encourage you to be eating, to be drinking, and just taking care of yourself in general. So if you need to get up and go do something, go do that. And hopefully the time that we've built in will give you space to do that as well. So I make no assumptions that everybody knows how to use Zoom. Even when I'm teaching at the UO, when I'm working with grad and undergrads, students, or even faculty, I make no assumptions about using Zoom. So we're going to do a brief Zoom overview. And I also want to share that we've got Tony here. Tony is the director of education at Mod Kearns, and they're going to be our technology help for Zoom. So if you're running into any hiccups, Tony's going to be here to help you with getting the troubleshooting going and trying to get you up to speed on what we're up to in class. So let's explore Zoom together before we get into the workshop content. Getting to know Zoom. So everybody should have access and see on their screen a control bar. It's usually located at the bottom of your Zoom screen. Sometimes it can move around. It could be at the top, it could be the left, it could be at the right. Right now, mine is at the top of my screen. And it contains a lot of buttons that give you the ability to control how you participate and interact with Zoom. So the first that I want to practice with all of you is turning your audio and video on and off. You don't have to turn your video on if you don't want to, but I'd love for all of you to just like practice switching your audio and video, either of those two, on or off. And Tony, if you could give me a verbal signal, just 'cause I can't see everybody. Let's practice that and then we'll move on. I'm hearing the click-ons and the click-offs. Okay, cool.
Yes, it sounds like everybody is doing their audio or camera pretty well.
Perfect. All right, let's move on. All right, next, more interacting on Zoom. Closed captions exist on Zoom. So what's the purpose of these closed captions? It helps you follow along with the instructor's voice. I love closed captioning being turned on. I'm someone with a disability, and so I don't use it solely for just like helping me hear what someone is saying, but I actually like to listen and read at the same time because it aids with my reading comprehension. So if you're interested in turning your captions on, you can click show captions that's located in your Zoom control bar, and Zoom should automatically translate those translate, I should say, transcribe what I am saying and turn it into text, and it shows up on the bottom of your screen. So that's optional. You're not required to do that. Next, let's talk about reactions. So the purpose of reactions, the way that I like to use them as a teacher, is typically when I'm teaching online, everybody likes having, for most part, everybody likes having their cameras off. So the way that I'm able to determine if we're able to move forward or get a temperature for the room is through reactions. So this is like nonverbal expressions and gives me a good sense of where we're at as a group. So in your control bar, there is an option for react. And I want everybody to click on react and click on the thumbs up emoji. And Tony, you tell me verbally if the thumbs up emojis are doing their thing.
Thumbs up are from everybody. Thumbs up from everybody.
Sweet. And that thumbs up automatically disappears too. The next reaction I want y'all to test is next one I want you to test is the raised hand emoji, that reaction. That raised hand gives me an audio cue and also a visual cue that someone has a question, or if I ask you a question, I'm like, yes or no, and raise your hand if everyone says yes, and you all raise your hands. The other thing to know about raised hands is when you put it up, it needs to be also manually clicked. It needs to be clicked on again to shut off. So everybody can turn off their raised hand. So click it off. And then try the clapped hands. I love doing celebrations in class where it's like, oh my gosh, we did great. And so that's another emoji that I like folks using too, is the clapped hands. All right, so moving on, next is we're gonna have polling in this class. So polls, I've got some preset questions. All of them are either yes or no's or multiple choice questions. It's all anonymized, so no names. If you're like, oh, I don't know if I'm right or wrong, I don't want to participate. No names, it's all anonymized. But I'm going to be introducing these polls. They're going to appear on your screen, and when they appear on your screen, please answer them. So I'm gonna release a poll, and I want you to respond to it. Okay, so the poll is going to show up on your screen. You're going to select your answer, and then you're going to click send to answer that poll. So I'll also be sharing what the questions are. So I'm going to release this poll. This is the first poll that I am launching. And I would like everybody to take a minute or two to read this question. So what is your biggest copyright concern as a visual artist? The options are protecting my work online, understanding how others can use my work, determining how people can use my work, knowing what I can use, knowing when I can use others' work, dealing with infringement, and other. So if you pick other and you know how to use the chat, put it in the chat. And it looks like we got everybody voted. Okay, so I got 7 of 7 responses. I'm gonna end this poll and I'm gonna now share the results. All right, give me a thumbs up if you are all able to see these results. We got protecting my work online had the most responses. 57% of the class said that's what they're interested in learning about most. So give me a thumbs up if you're able to see this poll. And Tony, you let me know if that's good.
Yes, it seems like everybody can see it.
Wonderful. Okay. All right, so I'm stopping my share. Perfect. Okay, next is let's address some social tech communication challenges that frequently happen on Zoom. This is our last getting to know Zoom before we get into copyright. So there's 3 big challenges that I've encountered both as a student and then as a teacher when learning on Zoom. These include video freezing. And there's a potential solution to dealing with the issues of the video freeze. You can turn off your video and audio, and this helps to speed up your internet connection. That's typically why um, freezing happens, where a video is paused and audio has also paused. So I encourage keep video and audio off because it improves your internet connection or bandwidth. Next is speaking over each other. So I like to use the practice of always having my audio off when as my default when I'm on Zoom, and only turning it on when I need to speak or if I feel like I really need to say something. I also will use my raise hand pretty often. Um, I like to say that because I'm from Massachusetts, speaking over people or talking over folks is like a cultural practice that I've just had my whole life, and this is a strategy that I like to use as you know a very extroverted, talkative person who's socializing or engaging with people on Zoom. So I recommend audio off as a default. And then next is dealing with screen fatigue. This just step away from your computer and take a break. Um, Also, like if you feel like you need to just leave the workshop because you're just like have been on a computer for too long, no sweat. There's going to be a recording available later. Okay, so copyright. What is it? How does it relate to artists? So let's start with the definition of what is copyright. Copyright is a form of intellectual property protection that is granted by the United States government. It is a law. It's a law that's been specifically designed to to protect the ownership of an original work. So we'll get into what constitutes an original work. Hint, hint, hint. Your artwork is an original work. So again, this law, it is a law of the land. It's existed for a very, very long time, and it is mainly governed by the Copyright Act of 1976. And this Copyright Act gives us a framework around how do we protect our rights, what rights for a creative work is protected, legally protected, and how are these rights enforced? So, 2 things to remember about copyright, and when we're talking about copyright, it's what is an original work and what is actually protected by copyright. So, what's an original work? An original work must be independently created. So independently created by an author. Author can also mean a creator, an artist. It's anybody who makes something that is in some type of tangible form. Um, so an original work must also possess at least a minimum degree of creativity. So this is the artistic's choice in composition, color, perspective, arrangement. All of these can satisfy the requirement for possessing a minimal degree of creativity. And so an original work, how for a creator, how is this applied? It's a literary piece of work, it's a musical piece of work, it's a dramatic piece of work, it's an artistic work. This includes paintings, drawings, photographs, sculptures, and other forms of visual art. Um, so what is protected by copyright law? The law, copyright protects this tangible expression of that creative work. It's not protecting the underlying ideas, concepts, or techniques. It is protecting that painting you made. It is protecting that digital photograph that you took. It is protecting that sculpture you made. So it's this expressive, creative work. So as an artist, what does this mean? What does this actually mean? What's protected and what's not protected? So your finished work, again, I've said that, your finished work is what is protected. What's not protected? Style, concepts, themes, and techniques that you've used to make your artwork. Is your copyright protected automatically? Yep. Yep. The moment you create that original work and it is in a fixed, tangible medium, meaning you've expressed on a canvas, on a piece of paper, in a digital file, your work is automatically protected by copyright. That's when it begins. So, can I register? So, I always get this question of, well, do I need to register my work with the federal government? And that office that you would register with is the US Copyright Office. And my response to that is like, yeah, you could totally register your work, but guess what? It isn't required. But a benefit of registering your work with the US Copyright Office, I've listed several of them on this slide. They include, you'll have if someone were to like sue you, you have by having a registered work with the Copyright Office, you have a stronger legal standing. You have the ability to sue if someone is stealing from you. There you can have claims to statutory damages. You can there's attorney fees that can be covered. And your registration within 5 years of publication establishes this more like a presumption of validity in court that this work is yours. So another question I get asked a lot is, well, how long does copyright ask? What is the duration of my copyright? And this question can have multiple answers. It can be complicated because laws do change. So duration of copyright protection. For works that have been created after January 1st, 1978, your copyright protection lasts for the individual creator's life, which is your life plus 70 years. Works that have been made for hire, and we'll talk about work for hire later. Works made for hire. So if you were contracted or hired by somebody to create a painting for their collection or say for an office space, it's 95 years from when you have either published it online or it's been published in a book. I know graphic designers and illustrators that will have their artwork published in books, and that's a work usually that is considered a work for hire. And so it's 95 years from publication or 120 years from that date of creation, whichever expires first. And then there's also joint work. So we as artists, like we tend to collaborate with people. We can collaborate with people and make art. So there's this concept of joint works, joint creators, 70 years after the death of the last surviving creator or author. And then for continuing with duration of copyright protection, for works created before 1978, the duration rules can be more complex and depend on publication status and other factors. I want to pause for a second if you're like, why are things changing? It's because of Disney. Um, it's because of Disney. And I can share more information about it's because of Disney, where a lot of copyright law in the United States started getting changed because Disney's been making work for a really long time, and they want to make sure that their creative assets that they make a lot of money off of stay in copyright and never go out of copyright. So this never going out of copyright, um, when something gets out of copyright, we consider this copyright free or public domain. So if you are using artwork that was created before 1930, as of this year, so January 1st, as of this year, any works published before 1930 is not protected by copyright and is now copyright free or in the public domain. Okay, let's do a poll. Let me get that poll. I got another poll for y'all. And I am going to launch this poll now. So this poll, the question I want to ask y'all is, do I need to register my work to have my copyright protected? Do I need to have registered my work to have my copyright protected? True or false? Okay, got 6 of 6. We're good. I'm going to close this poll and share the results. And guess what, everybody? You're right. You are 100% right. The answer is false. So, yeah, copyright is automatically protected from the moment you create your work in its fixed, tangible form. Registration is not required. Great. So let's now talk about the rights within copyright. What rights do you have as an owner of an original work? So within the US Legal Code, Title 17, there's various categories of rights that you have. The right to reproduce, the right to distribute, the right to display, the rights to perform, and the right to create derivatives. Now, you, at the moment of creation, you got all these rights and they are exclusive to you. It gives you total control on how you say your artwork gets made. So let's go through these rights one by one. So first, starting with the right to produce. What do you control? And what can someone else not do? So with the right to reproduce, you alone are the person who can make copies. And I use paintings and prints a lot, 2D forms of artwork for these for these lectures and workshops I run. So this applies to everything that you make, original work. So to reproduce, the right to reproduce, you alone are the one who can make copies of your painting, whether as prints, in an exhibition catalog, or as a digital image. Someone else cannot scan or photograph your artwork and make copies without your permission. So the right to reproduce really is all about copies. The right to distribute. What do you control? You control how your artwork is sold, shared, or distributed to the public. Someone else cannot. So an example I give here is a gallery needs your permission to sell limited editions of your print, to sell limited editions of your print of that of your sculpture. So if they took if there's pictures of your sculpture, like they gotta ask permission to reproduce those pictures, or different editions, prints of your sculpture. Um, and also a publisher, if someone were to ever ask to use a picture of your artwork, that picture, that publisher, maybe someone wants to put it in a brochure or a book, they have to ask you for your authorization, for your permission to distribute an image of your work. The right to display. You control when and where your work is exhibited. So someone else cannot, so a company, for example, they can't use your painting as decor in a commercial showroom without your permission, even if they've legitimately purchased the physical artwork. They have to work with you, so they have the right to display it. The right to perform. You control. You control when your video art, installation, or other type of visual performing art happens. Someone else cannot take your project, take your a digital or your digital art installation, and perform it or have an audience view it without your authorization. And then finally, we've got the right to create derivatives. Only you have the control and authorization for your work to be adapted. So someone else cannot create merchandise that features your designs or modifies a photograph that you took for a poster or use your painting as a basis for another artwork. They need permission. Don't worry, we're getting to the Q&A. Myth versus reality. There are many misconceptions that visual artists can have as it relates to ownership and copyright. So I got like 4 examples here. On the left, we got a myth. We got myths. On the right, we've got reality. So a myth that I hear pretty often when I am doing copyright consultations, and it's my past job when I was a visual arts librarian, and even today as a digital librarian, helping people publish online, or in books or in other places. The first is, and I hear this all the time, the myth is, I need to use the copyright symbol for protection. The reality is the copyright symbol is actually optional in most countries, though it's still recommended to use it as a deterrent. So we're thinking about legal enforcement, right? So copyright symbol, the myth is it's optional in most countries, though it's still recommended as a deterrent. Another myth is I can't copyright my style. Yeah, that's correct. Copyright doesn't protect styles or techniques, only specific expressions in a tangible form. A third is if I post my artwork online, I lose my copyright. That is 100% wrong. Posting your artwork online does not void your copyright, though it may put your work at risk, at an increased risk of unauthorized use. And I've got stories that I can share related to this. Not personal stories, but friends of mine who have had their work or images used in unauthorized ways. And then another fourth myth that I hear is if someone changes my work by 10 to 20%, it's no longer infringement. So this percentage where it's like if I tweak it like 20% of the way, I'm not breaking any rules. I'm not violating anybody's rights. So guess what? There is no fixed percentage rule. The legal test is substantial similarity. So they're talking about how similar is a work if you compare it to each other. So I'm going to stop my screen share for a second. And this is where we're going to do Q&A. If you have questions, you are welcome to raise your hand, and I'll call on you and you can ask your question over audio, or you can add your question in the chat. One One of my teaching methods is I go silent for about 5 to 8 seconds because I know bandwidth can be a challenge for some folks if you're remoting in from somewhere where, internet's really slow. So I'm going to give y'all a moment to, if you have any questions about copyright specifically, what we just learned, feel free to raise your hand or put it in the chat, and I'm going to wait. I'm going to wait a little bit to give y'all moments to think. Okay, we got a question in the chat. How does this apply to collage? I don't do collage, but I'm just curious. Yeah. So we're going to talk about transformative use. Transformative use relates a lot to fair use. And the next one of the so we'll talk about fair use. And so I'm going to come back to the collage question when we get to talking about using other people's work. And I have an example. I have actually a collage example in a case art case law, an example to show y'all. So I'm gonna put a hold on that one, and I'm gonna put a question mark next to it so I know to go back. The second question we got is, what do I do if the work I want to use is not dated or signed, i.e. a vintage postcard? How do I know if I can use it? Love this question. I don't go into the nitty gritties of something called orphaned works. In this workshop, I don't really talk about orphan works, but um, an orphan work is basically, hey, there's no date on this, and I don't know who the creator is, and I found this like vintage postcard or stereo card like at an antique shop or at a flea market, and I don't know whose it is. Well, let me share this. Typically, when you find postcards today, they usually will have they'll be digitally printed, right? Um, you may find postcards, or stereo cards or at flea markets or antique shops. And I always say, do your due diligence to try to find out who the creator is. But sometimes that information is not available, or when that information, like the company name, is on the postcard, and you go do a quick online search to see if that company still exists. This is you doing your due diligence. A lot of times companies go out of business, and sometimes their copyright get bought up by another company, and so what I'm explaining right now is called provenance research. Like, where did it come from? And so, yeah, sometimes you can't find it, and sometimes that information is not readily available, and you can classify that as an orphaned work. I run into this a lot as an archivist. I'm a trained archivist. I do a lot of digitization, a lot of scanning. I run into this a lot with cultural heritage materials that, I'm not sure about when something was made or published. So if something looks like, you get a stereo card, for example, think about the time period, do like a visual analysis. Or if you've got like a black and white photograph that is a silver gelatin print, and it looks really old, like really old. You can see like the clothing people are wearing. It might give you a signal of what the time period is. So you do have to do a little bit of your due diligence and research. And my advice is just document that you did due diligence. Where you found something, in my opinion, as a visual artist and as like a research librarian, part of your studio practice and just your practice in general as an artist is like keep track of where you find stuff. Like annotate it in your notebook, put it in your sketchbook. Um, it's a good practice to just like keep track and remember where something came from, right? So that's a really great question about like finding work, like vintage postcards. I'll say that most of the time if they're published, Made before 1930, they're out of copyright and you can use it. But if they were published in 1970, that postcard company might still exist. They might not, but it's using this duration of copyright as another measurement stick. Susan, give me a thumbs up if that answers your question.
I'm walking, so I can't give you a thumbs up, but yes, you did. Thank you.
No problem. I love audio. So I'm happy. Thank you for confirming. All right, sweet. Any other questions before we continue on? Okay, I'm going to share my screen again, and we're going to continue with our workshop. Okay. I'm going to do a temperature read really quick. Would everybody give me a thumbs up if you would like to have a 10-minute break? And Tony, if you could tell me if majority of the class wants a 10-minute break. We've been on Zoom for about 40 minutes.
I'm gonna give it a couple more seconds, but I'm not seeing any thumbs up right now.
Okay, I'll check in with folks later. All right, let's keep moving ahead. Okay, part 2, licensing your work. Sorry. Part 2, licensing your work. So a key thing I need to remember, we just reviewed it, we just learned about it, I should say, is you have ownership over the rights to your work. You are the owner, you have rights. So how are these rights actually applied when somebody wants to use your artwork or images of your artwork? So let's talk about what a copyright license is. A license is the legal permission that you give or you grant somebody or another party a specific way to use your work. So that specific way of using your work, that's the right for use. Those are our the various rights that are assigned to your copyright. We're gonna review those again. They'll come up in a previous slide if you've forgotten what they are. But the way I like to frame copyright licenses is think about this like the ability for you to rent out certain rights while still maintaining your ownership. So with a license, you are not assigning ownership. You are giving permission to use. You keep ownership. I'll say this too. I should have added this little caveat on this slide is you can give away your ownership, but for a license for this purpose, like you are not giving away your ownership. You are just giving permission for somebody to use your work. So here are these key aspects of what is a license. It's permission, not transfership of ownership. So what does permission mean? You're retaining ownership while allowing others limited usage. So you're granting permissions. Next is this customizability. So licenses can be customized because you're the one who determines what rights you grant somebody. This can include for length, duration, where, under what conditions. This customizability, again, it's associated with the rights that are in Title 17 of the U.S. Legal Code. Another aspect of a license is it's contractual. It's a legal relationship between you as a licensor and the user, the licensee. It's also a monetization tool. And I'll talk about in a little bit how one super famous artist has used licensing as a monetization tool. But this allows you to generate income for your work without you giving up more control than you would want to. They're also revocable. So most licenses can be terminated under certain conditions. Just those conditions need to be written into a license. And then also they offer protection. So unauthorized use beyond the scope of a license, it's copyright infringement. So here's this review, this bundle of rights for shaping your licensing agreement. We got the right to reproduce, distribute, display, perform, and create derivatives. These are your bundles of rights that you would frame in a licensing agreement. You may be aware of what exclusive versus non-exclusive licenses are. So we've got a table here. On the left side, we've got our exclusive license, and then we've got a non-exclusive license. And how are these different? So they're different in ways of scope, formality, payment, and duration. So starting with an exclusive license, this is a license that grants the rights to only one licensee for a specific purpose or within a specific territory. Scopes around this is only the licensee and not even you, the artist, can use the work in a specific way. And for formality, this must be it has to be in written form, and it needs to be signed, not just by the licensee, but signed by you. Payment with exclusive licenses is typically high fees due to this exclusive licensing. And the duration, it's specific terms for length of time. Non-exclusive, this is where multiple parties, including yourself, are allowed to use the work simultaneously. So you're not giving exclusive use rights. Again, it's you and whoever you grant use rights, non-exclusive rights to. So the scope for this one is you can grant the same rights to multiple licensees. So if you had multiple parties you were working with to who wanted to use your photograph in your illustration or painting or photograph in books or brochures, you can create a license that allows everybody to use it. Scope is formality. It can be oral, it can be implied, though written is always strongly recommended. Payment, generally lower fees than an exclusive license, but it really just depends on context. And then duration, I should say that for duration, again, this is it could be time limited or it could be perpetual. And, exclusive licenses could also be perpetual or in perpetuity. So let's look at an artist that is pretty famous, Keith Haring, right? So Keith Haring is my chef's kiss, great example of an artist who was really smart about before their death. I mean, they're a famous artist, right? Before their death, Keith Haring, he established the Keith Haring Foundation. And he decided that he wanted to have this foundation be able to create revenue to enhance his legacy and also provide funding for children's programs and AIDS organizations. And so the foundation has a pretty successful licensing program. So when the Haring Foundation established this licensing program, they were pretty smart about branding, brand management, and art management. So the Haring Foundation, they are very selective about their partnerships. They have this tiered licensing structure. They have and this, again, when I say licensing success, this is what they build into their agreements with partners. They don't just partner with anybody. Keith Haring's work, it's used by a lot of skateboard companies, streetwear. It's used by Uniqlo. I'll get into that a little bit more later. But anyway, rights management, and also in these license agreements, the Haring Foundation has quality control provisions. They have to review anything that their partners put out. They got to approve it. They build that into the licensing agreement. So here's an example of a skateboard company that has an agreement with the Haring Foundation. And on the screen, I actually have highlighted here this, the Haring Foundation makes it a requirement that if this company, they're called Alien Workshop. This is one of their skateboards, the Rare Deck skateboard. The Haring Foundation, they typically do limited release, like exclusive releases with companies. And so this is an example of one where this skateboard was designed and sold, and it's like $550. It's an expensive board, but they also require that you have to disclose like official licensing by the Herring Foundation, and what the image is. So they like dog jumping imagery, like that's Herring's artwork. So that's kind of like crash course in licensing. Now I want to talk about how work for hire, and work for hire does relate to licensing, because it's, again, licensing is all about agreements and how someone can use your work. With artists, I get asked often about, hey, I was hired for a job, and is this work still mine? So typically when you are hired by somebody, so commissioning from a party or you have an employer, a work made for hire is a work where your employer or the commissioning party is considered the legal author and the copyright owner, not the individual who created it. So two ways a work becomes a work for hire is, one, it's created by an employee within the scope of employment. So examples include in-house graphic designers, staff photographers, or employed animators. And then two, independent contractor and special conditions. So there must be a contract, something in writing. You must it must fall within a specific type of work that is being made for a specific job. So contribution to collective work, if you're working for a magazine. So if you're working for a magazine like the New Yorker and your illustrations are published in the New Yorker, work for hire. This goes for folks that work on movies too. And then specially commissioned work too. These are works for hire. And again, contract. So we're gonna release a poll, and let me launch this poll. Okay, true or false? An exclusive license does not grant the rights to only one licensee for a specific purpose or territory. And I got two more folks waiting to vote. I'll give you a couple more seconds, and then we will do the reveal. Okay, I'm gonna end that poll, show those results, and yeah, you're right. So 100% yes, you are right. The answer is false. An exclusive license does not grant the rights to only one licensee for a specified purpose or territory. The work must be used in a specific way. Agreement signed by the owner often has high fees and is used only and can be used only for specific durations. Okay, I want to now talk about a type of license called a Creative Commons license. And we're gonna watch a video about Creative Commons, but the thing I want to get across big time about not just what is a Creative Commons license, you'll be instructed on what that is, but I want to just say that you retain ownership with a Creative Commons license. Okay, like a lot of misconceptions is I don't retain my ownership if I use a Creative Commons license. That's not true. So I wanted to just say that before you even find out what is a Creative Commons license. So I've got, where are we? Hey, buddy, what's going on here? Creative Commons. All right, so I'm going to stop my share for a second, and I am going to get the video loaded, and then I'm going to share my screen again. And I'm gonna stop. I actually forgot to make sure the sound was also, yeah, sound is shared. Perfect. Okay.
Have you ever wondered how to download and share digital content legally? How do you let people know that you want them to reuse your own work? Creative Commons licenses can help you do both. We'll show you how. Our world's exploded with digital opportunities. Now we can communicate, share, and work together using the exceptional distribution network that is the Internet. Information and content can fly between us in exciting new ways. But it's important to know that when something is created, say a photo, a document, or a music track, it's automatically protected by copyright. Copyright enables people to say who can share and reuse.
I wasn't sharing correctly. My bad. Let me start that over. All right. Tony, you able to see the video?
Yes.
Okay, I'm gonna start that over. Thank you for calling that out. All right.
Have you ever wondered how to download and share digital content legally? How do you let people know that you want them to reuse your own work? Creative Commons licenses can help you do both. We'll show you how. Our world's exploded with digital opportunities. Now we can communicate, share, and work together using the exceptional distribution network that is the Internet. Information and content can fly between us in exciting new ways. But it's important to know that when something is created, say a photo, a document, or a music track, it's automatically protected by copyright. Copyright enables people to say who can share and reuse their creations. You must always obtain someone's permission before sharing or reusing their work, even when it's posted online. But what if a creator wants everyone to use their work, without the hassle of granting permission over and over? This is where Creative Commons can help. Creative Commons provides licensing tools that are free to use. You can apply a license to your work, which refines your copyright and streamlines how you give permission. Zach here downloads a photo called CC Kiwi that he wants to use in his science project. He can do this without asking Kiri, the photographer, first, because she's already given permission with a Creative Commons license. Kiri's license is legally robust, but easy for Zach to understand. She's told the world, including Zach, that they can use CC Kiwi as long as they acknowledge her as the original photographer. There are more rules Kiri could have included. Creative Commons licenses are made up of license elements. You can think of them as rules, and each have their own special symbol. This is attribution. It means that Zach must acknowledge Kiri when he publishes his science project containing her photo. This is non-commercial. It means no one else but Kiri is permitted to make money from CC Kiwi. Tim wants to print the photo onto t-shirts and distribute them to friends. He can do this, but he must not sell them. This is no derivatives, and it means that Kiri hasn't given permission to change her photo. Kate can use CC Kiwi on her design blog, but will need to ask Kiri before retouching or mixing up the image. And this is share alike. It means new creations that use CC Kiwi need to carry the same license. Jack incorporates his own remix of CC Kiwi in his video installation, but he must share the work under the same terms that Kiri has. Each Creative Commons license gives permission to share and includes the attribution rule. So people who find your Creative Commons licensed work are automatically allowed to share it, but are required to acknowledge you if they do. The other three license elements are optional, and you can choose which ones to add, if any. Here are the 6 combinations that make up Creative Commons licenses. The difference between them is how many rules apply when someone wishes to use your work. The attribution license allows reusers the most freedom, and the attribution non-commercial no derivatives license allows the least freedom. The attribution license and the attribution share alike licenses are sometimes referred to as free cultural works approved licenses. These 3 licenses restrict commercial use of a work. And these 2 licenses do not give permission for adapting or remixing. These 2 licenses require new works to be licensed under the same terms. To choose and apply one of these licenses, and to view their terms in more detail, visit us at creativecommons.org.nz. Or you can answer some questions to help you decide which license best suits your needs at creativecommons.org/choose. There are some good ways to find other people's Creative Commons licensed work online. You can use a search filter by going to the Creative Commons website. Or why not try the Jamendo website for music, Flickr for images, or Digital NZ for New Zealand.
Okay, I'm gonna pause on that. I'm gonna stop my share. And I'm gonna bring back our PowerPoint. Okay. As I want to say, I meant to like talk about work for hired after Creative Commons, so my bad. But let's talk about Creative Commons a little bit more. Okay, so Creative Commons. As that video was sharing with us, Creative Commons standardizes different types of licenses that you can use for free and apply to your work. Now, the main point of Creative Commons is not just to have these like readily available and human readable licenses available for us, because it's like licenses can be pretty legalese oriented, right? Well, on the Creative Commons website, and I'll be linking any resources I talk about, I have linked on a website that I'll be sharing at the end of class, and Creative Commons is on there. But these licenses, there's several of them that you get to pick and choose from. I will say that like some challenges that I have with Creative Commons involve my interest as an artist wanting to monetize my work when people use my images. And the primary reason for that is because I need to make a living. And I make money off of my artwork. But that's for specific, that is for like a set type of artwork that I make. I also take a lot of I studied photography. I do a lot of photography. It's not my main mode of artistic practice anymore. But you know, I've taken a lot of pictures of trees and I published them online. And I'm totally cool with people not asking my permission to use those landscape or nature photographs. But I want acknowledgement. I want to be given attribution that it is my picture. And so I used to use Flickr, which is a service for photo sharing, the social media photo sharing website called Flickr. It's also an app. But I used to create albums on Flickr pretty often and upload my photography there. And they allow you to apply a Creative Commons license. And they have a variety for you to pick from. So I used to upload my pictures there, and which made them findable in the Flickr database. And I was told once I got hits for how often something was downloaded. But if you're probably wondering, well, someone's required to give me attribution. Yeah, they are. Well, how do you know if they've given you attribution or not? You don't, unless they contact you or you find it online and your name is there or it's not. And we'll talk about that a little bit more when we get to protecting your work online and what the realities of that look like. Okay. So I'm gonna stop my share. And questions in the chat, or if you want to unmute your turn your audio on and ask your question. Yeah, do CC cross countries? Yes, they do. They're international. Love easy response. Yes. I also say if you upload videos to YouTube or Vimeo, Creative Commons is an optional license that you can apply to your work that's uploaded to YouTube or Vimeo. Facebook and Instagram don't have it. Any questions about licensing? I'll pause and be quiet for a little bit as folks think. Okay, let's move along. Does anybody need a break? We are at the hour mark. We got an hour left together. Am I hearing or seeing any responses? So, all right, fellow warriors, let's go. Okay. Let's now get into using other people's work. So give me a reaction, any reaction. How many people are aware about the Obama Hope poster and the controversy around it with Shepard Fairey? Give me a reaction. Give me a thumbs up if yes, you are. And Tony, if you could tell me if there's any thumbs up.
I'm only seeing one.
Okay, love it. Yes. All right. So what we're looking at, so before I dive into the what are the lessons we can learn about Shepard Fairey's experience? So first, Shepard Fairey is an artist. He does a lot of printmaking, specifically lithography. So back in 2008, Shepard Fairey created a print. He created this image that became pretty iconic in 2028 when Obama was first running for presidency. And it's known, this image on their screen is known as Hope. That is the title of this work, Hope by Shepard Fairey. So I want you to imagine yourself. I want you to imagine yourself as a visual artist who is planning a new work that's inspired by current events, similar to Shepard Fairey's approach with his iconic Obama Hope poster. So here's your plan. Your plan is to create a portrait of a contemporary public figure for a series of political art that will be exhibited in galleries, sold as limited edition prints, used on merchandise, and shared widely on social media. So your reference, you found a compelling photograph in a major news publication that perfectly captures the mood and expression you want to convey. So that is your scenario. So let's talk about Shepard Fairey. 2008 comes around. Shepard Fairey found a photograph on the that was published by the Associated Press. And this photograph of Barack Obama was taken by a photographer named Manny Garcia. Shepard Fairey then used this photograph as the basis for his Hope poster. And he did this without permission. So he took the picture and made art out of it. Shepard Fairey created a stylized illustration that has limited colors, added text, and decorative elements. So Shepard Fairey, when he got sued by the Associated Press, by AP, he initially claimed that his work was based off of a different photograph. He claimed that the photograph he used of Obama was essentially a different one that he found that was taken of Obama in 2007. I'm sorry, 2006 instead of 2007. And then later, as you know, this lawsuit is going on, he later acknowledged to using the Associated Press's photo. But he claimed fair use. And fair use was his legal argument of why it was okay that he used this AP photo of Obama. And the way that he distributed it, so remember the licensing, all those bundles of rights that come along with copyright, Shepard Fairey was making a lot of money off of this artwork that he had made. And he was claiming fair use. And fair use is built into our copyright law. But this work was distributed widely and used for merchandise sales. So what were the outcomes of this lawsuit? Well, AP was filing copyright infringement against Fairey. He countersued again, claiming fair use. The legal battle lasted for years. I think it ended in maybe like 2012 or 2013. Oh no, it's on the screen, Kate. It ended eventually in 2011, and Shepard Fairey lost. He agreed to pay AP compensation, and actually, like both parties would share the rights to make and sell the image. So Shepard Fairey lost. Let me go back. Shepard Fairey lost this because it wasn't as transformative as it needed to be. His clear fair use argument that he made in court with his lawyers wasn't strong enough. So let's talk about what fair use is. Fair use is a legal doctrine within the US copyright law. And this fair use permits the limited use of any copywritten material to be used without permission. So no permission needed. You can just like take that pic. Supposedly you can take that picture of Obama or someone's artwork, and you don't have to ask the owner or the rights holder. And this is so fair use. Again, it's a legal defense. It's a defense. It's a doctrine. It's not a law. It's a defense for why you're not asking somebody's permission and you're going to use that work any way you want. But again, it's a codified legal doctrine, and it serves as an exception to the copyright owner's exclusive rights. So I always emphasize this: fair use is not a right; it is a defense. It is an argument for you to develop on your own for why you are using without permission somebody else's work. So one, fair use is invoked after being accused, after you're being accused or someone is being accused of infringement. For fair use, the burden is on the user. So you, as someone that is using somebody else's work and are claiming fair use, the burden of proof that qualifies something for being fair is on you to argue and say, I'm using it in this way and it meets a fair use judgment, an evaluation. It also is determined on a case-by-case court basis. So if you were sued or you knew somebody that was sued and you're claiming you as the user of somebody else's work, it's case by case. It's not just like a blanket statement. Like you got to go to court and it's gotta be litigated. There's also no guaranteed formula. So I get a lot of people asking me like, okay, like, isn't there like a calculator I could use? And I'm just like, nah, nope. This is it's a judgment that you have to decide when you are using somebody else's work to make new work of your own. So what are these like aspects or factors of fair use? So there's 4 factors of fair use. The first is purpose and character of use. So the key question if the key question that you are arguing for purpose and character of use is, the question that's going to be asked of you is the use of this portrait of Obama, is it transformative? Meaning, is it adding new meaning, a new message, an expression? Things that the courts consider include commercial versus non-commercial use. Like, are you using it to make money? So this the picture of Obama that was used by Shepard Fairey, yeah, it was used for merchandising. Like he was making money off of this photographer's work. But he's claiming, it's okay though, because this is my new artwork that I made from it. Commercial use weighs against fair use. Again, I just shared, like, somebody's making money off of it. Like, that commercial use weakens your fair use case. If you are using it for educational purposes, or for nonprofit purposes, typically that your purpose and character, your purpose of use is viewed more favorably by fair use. And this concept of transformation, the 2 questions are asked. How much does your work actually transform the original? And does it provide new insights and meaning or messages that strengthen your case for fair use? So creating a collage that incorporates a famous photograph to critique consumer culture is more likely will favor it could be more in favor of fair use than reproducing the photograph with just color changes. The next factor that we have is the nature of the copyrighted work. This is the nature of the work that you are using. Key question about this factor is what type of work is being used. So creative versus factual. Using something that is a highly creative piece of work like art or music or fiction can less likely be considered fair use. Using something that is factual in nature, like a historical document that you get from an archive or something from the news, more likely can be fair use. And again, I want to say everything has to be weighed together. You got 4 factors of fair use. You got to build that argument when considering all 4 of these factors. Another consideration for this factor is the nature of the copyrighted work. So is it a published work versus an unpublished work? So using published work is more likely, using published work is more likely to be fair use. Using unpublished work is less likely to be fair use. So the next is this factor 3, the amount and substantiality of use. How much of the original work did you use both quantitatively and qualitatively? So how much is being used? What courts consider when we're talking about quality is, are you using a small portion or a big portion? Are you using an entire work? Like if you're taking a painting and you're just like making a Xerox copy of it and you're like, this is my work. Does the court consider that? Is that part of your argument of saying, yeah, it's fair use because I made a copy of it and it's the entire thing. And I would be like, no, fair use doesn't protect that. For quality, taking the heart of the work can be weighed against fair use, even if it's like a small portion of it. And also taking peripheral elements could favor fair use, even if the quantity is pretty large. But again, I want to just keep reiterating that even though I'm highlighting these yeah, you could do this and courts consider this, it really is going to be the full package of your argument and your justification for fair use that the court decides. An example for this is using a small portion of a photograph as one element in a larger collage is more likely fair use than using an entire focal subject that comes from a photograph. And then having that, large focal element be the main part of your artwork. And then finally, for the 4th factor, we've got a potential effect on the market. This is where money comes in. Are you affecting the market? Are you harming an existing market or a potential market for the original work? What the courts consider is this a market substitution? Could your work replace the original in the marketplace? Does it serve the purpose? Does it serve the same purpose and audience? License opportunities. Was a licensing opportunity readily available? Would your use typically be licensed in your industry? And so there's also derivative markets too. But the example for this one is creating a limited edition of fine art pieces that incorporate elements of a photograph is less likely to harm a market than using the photograph on a mass production scale that competes with the photographer's own licensing program. So I always believe, and this has been shown in case law too, is that the key to fair use for artists is answering the question, is it transformative? Transformative use adds new meaning, message, and expression to an original work, or uses it for a different purpose than the original work, the original creator had intended. So why transformation matters is the courts increasingly have been focusing on the transformation as the most important component to these fair use arguments. The stronger the foundation, stronger the transformation, it sometimes can outweigh commercial use. And I'm going to show you an example in an upcoming slide of two artists' work where that's been a factor. Transformation also reduces market harm. And anytime you're working towards transformative use, you're creating a very, very strong fair use claim. So there's a spectrum of transformation. This examples of low, medium, and high. So let's start with the low and work to the high. So with low transformation, you're reproducing with minimal changes. You're merely shifting formats and mediums using for the same basic purpose as the original. An example of this is that the Xerox copy or scanning a photograph and adding a filter to it. That's a low transformation example. A medium transformation example would be incorporating work into a larger body of work, recontextualizing the original, and also adding significantly new elements. So you're using a portion of a photograph in a mixed media collage. And then highly transformational, you're creating parody or critique of the original. You're completely repurposing for unrelated function. You're using raw material for an entirely new expression. So you're appropriating commercial imagery to create commentary and criticism and commentary on consumerism as an example. So here are two artist examples that transformative use in case law, where transformative use has come up in case law. So the one on the left, this Carew versus Prince, this is from 2013. And the one on the right is Blanche versus versus Koons in 2006. So Richard Prince, he's an artist, photographer. He used a photograph by Patrick Carew, Kairou's. He used his photograph in a collage series. And the court found that most of the works were transformative due to different aesthetic. And a key lesson learned with this legal case is that visual changes can create new meaning. The second example, the Blanche versus Koons. Jeff Koons used Adrienne Blanche's fashion photographs in a painting. And the court found it transformative in its purpose because because they had sharply different objectives. And the key lesson here in this case was different artistic purposes can justify appropriation. So I'm gonna question time. Questions in the chat, or you can unmute yourself. And I'm gonna give you a second to think through questions and share. My little dog is trying to get into my office, so I will be right back. And Whitney, I hope that this part of our time together has given you the answer related to collage work and copyright and using other people's work. And if it hasn't, feel free to ask another question. Okay, I'm gonna do a temperature read on the room. Give me a thumbs up if you feel really confused by copyright. Okay, here's another question. No one's giving me a thumbs up. Give me a thumbs up if you feel really confused by licensing. I know you're all lying. Okay, give me a thumbs up if fair use makes complete sense to you. Okay, I want to say this. This stuff is confusing. Um, I have been at teaching and advocating and working around copyright issues for years as a librarian. So I care very deeply about access and free use of information. And it really took me about 3 to 4 years to really get my head wrapped around this stuff and be able to talk about it. And so it can be kind of scary because it's like, oh my God, I can get sued. I'll say this, like a lot of the times you don't get sued. Um, there is a question in the chat. Fair use seems like a big risk, but I think I'm getting it. Yeah, I mean, like, we're always putting ourselves at risk, right? For using someone else's work as inspiration. If you are just taking it and you're using it and you haven't done anything to it. So it's like you're doing collaging, like, hey, think about fair use. Is it transformative use? Like, what are you doing? What's the nature of the work? How much are you using? Is it going to affect like the market that the original work exists in? Are you critiquing or adding criticism? What is the purpose or like the original intent of the work? But yeah, it's a risk, but it's also like fair use has allowed us to like not be hindered or with creativity, right? Like use it or you lose it is what I share with people. Use it till you lose it. Use it till you gotta use it or you lose it. How do pieces you make for a class apply to these things? Ah, yes. So we haven't been talking about educational context, but I work a lot with teachers in the classroom and what's protected and what isn't protected. So I always say, hey, you got to make a fair use judgment call. You making money off of those pictures you find online to put part of your slides? Or, hey, are you showing an entire film in your class? Hey, like, are you publishing your slides online anywhere? Or like, and so you have to, just because you work at like a university or in a K through 12 institution, doesn't mean that you're automatically protected. You still need to consider fair use. And I always tell folks like, just do your due diligence and like keep track of where you take stuff from. Nancy's question. What about using a work of art older than 1930 and that's part of a museum collection or private ownership? Is there some sort of extension to rights that applies the owner of the artwork beyond the artist's original copyright? So typically 1930, it's copyright free. So that's what I tell folks. Before 1930, the image, you can use it. We use that 1930 rule, well, the public domain. Like when something enters the public domain, it's copyright free. There are some museums that charge for digitization services, and that scan that they made, there can be a lot of going back and forth of like, does the museum own the copyright to that digitized image of that artwork, or is that image copyright free? You also usually have to pay museums to scan work that's not already readily available online. Something I do want to share about museums is that the Smithsonian, the Getty, the Museum of Modern Art in New York, there are many, many, many museums, Library of Congress. There are many museums, libraries, and archives that make historical works, so old stuff, and sometimes new stuff too, publicly and freely available online. So if you were to go to Google and you typed in Smithsonian Museum digital collections or Smithsonian Museum online collections, um, the records in their databases for all those works, the images of artwork that have been published online, those records will tell you if there's a Creative Commons license or how you're allowed to use it or not. Um, so that's my answer for public domain 1930. Great question, Nancy. Okay, we got another one. Whitney, would I be able to float an original image versus what I did with it to get an opinion of it if you think it would count as fair use? I don't know what you could you rephrase your question, Whitney?
Yeah, I don't know if I can share images on here, but I was just curious if I could show you all the original and what I used it for and just see what the group thinks.
Sure. And just so I do this as a disclosure, none of us are lawyers. Totally share your work, and I think it's great. We can talk about does it meet the factors of fair use? But yes, you can totally share your work.
Um, so that versus ah, sorry, trying to find Zoom again. And did that work?
Yeah, totally. So what does the class think? Feel free to raise your hands or in the chat. Do we think that, so in the chat, say yes or no. Do you think that Nancy has a really good fair use argument for, yeah, this meets fair use? So yes or no in the chat. People are saying yes, probably, yes. So let's yeah, I think so. Okay, let's break this down. I'm gonna I need to get my references here. So that way I don't mislead on, I want to make sure we get all the factors of fair use. Okay. So let's talk about, so the first, so the pug photo that you are using. Tell us about where you got it from.
I just Google imaged pugs, was doing a series of dog breeds.
Okay, so the purpose and character of use. You do you tell me more about is this use transformative? Do you think it's adding new meaning or expression? What do folks think? And what do folks think? You're welcome to also just give your opinion as well, why you think it is transformative. To use original photo for inspiration only. Yeah, so the name, in my opinion, like you're completely changing this picture. Like this is a pug, right? Like you just use the picture for inspiration. It's transformative because you look how stylized and how different it is, right? So I would say, like, yeah, the purpose of use for the other picture is stock photography. Like, you're using it as just a reference. You're not making a copy of it. Like, you're just using it purely as a reference, and you are transforming this picture of a pug into a new creative expression. Let me ask you this next question. Effect on the market. Do you plan on selling this image, your painting of the pug, uh, in the same marketplace as stock photography companies?
Not to my knowledge.
Okay, so you're probably not gonna have an effect on the market, right? Amount used. Now you did use a lot. You used the whole picture, right, of that face of that pug. But I'll also say, like, it kind of looks like every pug almost, right? Like
I was
the
going for, the breed standard generic, anybody
yeah,
who owns a pug could potentially see their animal in this, unless
looks like a
it's,
pug.
a different color.
Yep, looks like a pug. Um, so you used a lot of it. Okay. But are you taking the heart of that photograph? Like, you are. You're using the reference, kind of like the Shepherd Fairy in a way, kind of. Um, but let's talk about the nature of that creative work. Um, the photograph of the pug is what I'm specifically talking about. Um, it probably is strongly protected by copyright because it's licensed with a company. Um, and it's been published online. It's been published by a company. So the nature of the copyrighted work, like, they do have a strong argument of, like, well, stock photography is usually used as like reference or in PowerPoints or how stock photography is used. Um, but in my opinion, like, I'm not a lawyer. I think you would have a strong case for fair use, because of, like, it's a pug. It's not like this is Obama, right? Right? You're in a different market. Um, I'll say a lot of the times, like, if you're gonna make money off of something, and that's usually when courts come out or infringement comes out, that usually is the case. Um, does anyone have anything else that they would like to share, or like opinions about why this is fair use? And again, in this case, there's no right or wrong answers. We're just having discussion. This is not legal advice. The other thing I recommend is, if you're just looking for a reference of like a dog breed, um, on the Creative Commons it has a website, and they actually have the ability for you to search for Creative Commons licensed photographs or images. So instead of using istock.com or another stock photo agency, you could use a different resource that has Creative Commons licensed images of pugs. So I'm gonna show you also this feature. I'm gonna take control. I think this is actually really important to share. You can go on the Creative Commons website, or literally you can search for Creative Commons images by going to images.google.com. And this is gonna search Google Images for you. If I go back to my website address and I type oops, I'm sorry. Images.google.com, and what should I do? Let's type in pugs. We're just searching Google for images of pugs, right? Look at all these babies. They're so sweet. Up here where my cursor is dancing, there's something called tools. I'm gonna click on that. Tools gives us this additional these additional search features. And looky here where my cursor is dancing. Use rights. Creative Commons licenses. Look at all these pugs. They all have Creative Commons licenses on them. What picture we want to use? Let's say it's this one. No, let's use one from Flickr. Okay, here, let's use this one where my cursor is dancing. This thumbnail of this pug, below it, it has the website it comes from. So Flickr. And then below it, it has a caption or a title of that photograph. So I'm going to click on this picture of this pug, and I'm gonna go and visit the website where this picture comes from. And look at this baby, so sweet. I'm gonna scroll down. I forget where the Creative Commons licenses are on here because they changed the interface. I'm gonna scroll down, and yeah, here we go. Down here at the bottom on Flickr, they have additional information. License is an option. Some rights reserved. Let's click on it and check it out. It brought us to a Creative Commons license. And you can see here what you're allowed to do with it. So this picture of the pug, you are free to share and adapt. And then it gives into more details about what rules you have to follow if you're going to use this picture of the pug. So, but you have the ability to share it, so you can make copies, you can reproduce, you can redistribute it in any medium or format for any purpose, even to make money. And you can also adapt it. And adapt means I'm going to remix it, I'm going to transform it, and I'm going to build up the material for any purpose, even to make money off of it. So tell me, would this picture of the pug had served the same purpose as the one you found previously?
I think so.
Yeah. So my advice would be when you're searching Google, search for pugs, go to that tools option, and then limit it to Creative Commons licenses. And then you don't even have to, there is no fair use argument. You got a license to use it for your inspiration, and you don't need to worry about it.
Thank you.
You're welcome. Okay, let's stop your share. And are there more questions in the chat? Anyone have any questions to follow up? Okay, I got another one. Does a museum get a copyright of the piece when it is on display in the exhibit? So if you're an artist and you're working with a museum to display your work in an exhibit, usually you have a licensing agreement. You retain your copyright. You're licensing, you're giving the museum permission to display your work. And remember, part of that bundle of rights is display. So no, you're not giving the museum ownership of your work unless you have agreed to donate your work to them. But if you're just putting it in part of an exhibit, and that's the only way you're allowing them to use your work, then nope, they don't own it. Is there any chances for minors in the law? What does that mean? Can you tell me more what you mean by that, Kai? Changes for minors. What do you mean by minors? So nope, age has nothing to do with copyright for a person's age. Unless is it if someone under 18 made something?
I'm asking if someone under 18 has a piece in an exhibit, does that change the rights?
Nope, not at all. Like that kid owns that work. It's theirs. That's a great question. It's a really good question. But yeah, copyright has nothing to do with how old you are. It is like you've made a creative expression in a fixed medium, and that's the piece that is protected by copyright. Any other questions before we move on? Because we are almost done and almost out of time. And actually, I'm gonna like scoot us to moving along a little bit because we've got. I want to talk about how to protect your work online. So share and desktop too. Okay, let me get this open. Perfect. All right, so let's talk about protecting our work online. So how to protect your work that's published on the internet. Yeah, this can be hard because once you publish something on the internet, your work is still protected by copyright. But that doesn't stop people from taking it and using your content. Let's talk about the ways to mitigate protection issues. So galleries and portfolio sites. So we're talking about you protecting your work online and context for how you can share, or where you can share, I'm sorry. So where you can share online, your website. And we have galleries of pictures, or gallery like portfolio website, or you have an artist website and you have set collections of work. Some websites, those systems can allow you to disable somebody from coming to your website and right clicking and downloading your picture. However, people can still do screenshots. So one way to deter people from downloading from your website is you can stop people from downloading if the website you're publishing to has the ability to shut downloading off or shut right clicking off on that web page. I always recommend never ever put high res photos or high res quality pictures of your work online. Derivatives only, low resolution only. Because if someone's going to take your work and they want to blow it up to print it without your permission, it's probably going to get really pixelated and really fuzzy because you only like supplied a like 2-inch by 2-inch like thumbnail of it on your website, not the original 11 by 14. The other thing, so that resolution strategy, this lower quality when you're publishing online, is one way to protect your work. Next is you can do watermarking. So place a watermark on your images. If you're like, well, how do I do that? There's photo editing tools. If you ever get your work licensed to be distributed by a company, we just saw an example, the first image of the pug, and it just said dissolve in like a ghost text all over the photograph. That's watermarking. You're adding a stamp to show, hey, this is mine. So you could do that in like Photoshop or GIMP or other editing tools. The other thing too is like creating documentation. So that registering your work with the Copyright Office, that strengthens your protection. And also you specifically keeping track of where your work has been published online. So if like you put it on Instagram, what date did you publish it on Instagram? You put it on Facebook, you put it on your website. Your work is on a gallery or a museum website. Keep track of where your stuff is displayed or published and exhibited. And regularly search the internet. So Google has this really cool feature where you could take an image of your work and drag and drop it into the Google image search box. And instead of typing in words, the computer or like the search engine looks at the picture and it calculates, does all this like matrixy like stuff in the background with the data in the picture, and it makes predictions using statistics. And it will pull up websites that maybe have used your image, and it's a way that you could track how people on the internet are using images of your work that you published online. I've done that in the past, and it's pretty interesting to see where if someone publishes an image on Flickr, anybody can just go on there and take. I mean, anything on the internet, when you put something on the internet, you're putting it on the internet. Kind of like Wild West. And so again, this is like how to protect ourselves. But the reverse Google search and doing some regular searches is a pretty good strategy. It's also a fun one to see where your pictures could be being used. This publishing on social media, like I always say, like consider your goal. Like, are you like exposure versus protection? Right? Like social media is for exposure, like getting out there, engaging with an audience. Target your, like you can also set up targeted member access. So Patreon, it's closed access. You got to pay access to get to your work or like content that you're sharing, instead of making it publicly available. You can make again, I shared this earlier, like you can make strategies for where you publish, where you're like, nah, I ain't going on Instagram. People are just gonna take screenshots with their phone, like, but that's your call. Pinterest is another one, like just the resharing and resharing and resharing. And this, as the librarian in the house, when I'm talking about sharing, I'm talking about like not just the image is being shared, but what about all that captions and that textual information about the image? Does that travel with that picture? When it goes to, when someone brings it into another platform or publishes it or uses it another way, no, maybe not. And so that can lead towards appropriation, like how you're using it. I also want to say that like some artists will put information inside of digital files. So a lot of photographers do this. I do this a lot with my photography. Is I have a computer program on my computer, and it's called Lightroom. You can also do this with Adobe Bridge. They're both Adobe products, but it allows you literally embed copyright, creator information, date information, a description or caption of the work into the digital file that humans can't see it, but the computer can see it. Humans can only see it when they open it in a program and are specifically looking for it. Websites like Facebook strip all of that information that you've put inside of your digital file. They strip it. When you upload it, it's just part of their like processing. They'll remove all of this rich metadata or information about your work. Questions in the chat. Let me stop my share. Protecting work online. Questions in the chat. And it didn't even have to be about protecting your work online. Any questions? We've got some time. And while you're thinking and putting your questions in the chat, I'm going to mute myself and go get a survey because we're at the end of class. How do we protect against the use of AI training? So I love this question because I teach AI in the library at UO. Guess what? You put it on the internet. These companies can just use their bots to crawl the internet. How do you think generative AI has been trained? Tech companies are using the internet and just taking content from the internet and using it to train their bots. So how do you protect against use of for AI training? Don't publish online is one way. Put your content behind paywalls where people have to pay to get access. Publish online with a company, and I don't know if this exists yet, but publish with a company that like, you know, doesn't let their website be crawled by bots, or specifically used for AI. But yeah, that's the AI training landscape. It's all a big black box. It's all open, wild, wild west. It's a great question, Kai. Any other questions before we reach the conclusion of our workshop? Okay, sounds good. In the chat, I would love y'all to take the remaining 5 minutes of this workshop to fill out this survey. Let me delete that last chat. The link, if you could click and open that website address and fill out that survey. It would be incredibly helpful to both me and Tony. And after you've finished the survey, that is the conclusion of our workshop. I'm also in the chat going to share with you a website that you can use for reference later. It is a guide that I designed for this workshop. A lot of information. You might also want to have access to the slides later. There's a link in the chat to a website. It's a guide that I made for this workshop, and you can come to it. It's publicly available. And if you need to have a brush up on copyright licensing and using other people's work, feel free to come here and get those answers. Oh, thank you, Nancy. That's very kind of you. Thank you for attending.
Really, this is Nancy. It's I know it's kind of a wide world, and I really appreciate.
Yeah, no problem, Nancy. I love talking and teaching and discussing all this stuff. And I also want to open this up to like my information is on the website I just shared. So if you feel like you're like, how do I get a hold of Kate? What's Kate's opinion on this? You can reach out to me. I'm a university librarian at UO. Your tax dollars pay for UO. It's a public university, so I'm available.
Thank you. And do you, if I have somebody I would like to share the video with when it comes through, are you open to that?
100%. I'm going to actually put the link to the video on the guide, the website that I just shared.
Okay.
But that link to the video, eventually it will expire. But I'm also going to give Tony a downloadable copy. Like, I'm cool with it. I'm going to put a Creative Commons license on it. So cool with me.
Excellent. Thank you.
You're welcome. Oh, and thank you, Whitney. I'm happy this was also a useful class for you too. And I'm so psyched that you shared your fair use case with us. I love when that happens in class. This is great. And you 100% did not hijack.
Thank you. I just, didn't want to be the one to pull everybody onto a tangent.
No, it fit perfectly. It was wonderful.
Thank you.
Okay, everybody. Well, 'tis the end of our workshop. And I hope you all got something out of this. You have my contact information. The recording is going to be sent out by Maud Kern, so you will have access to this later. You also have an online resource that you can use, and that will be published. That's online. It's publicly available. You are welcome to share it with anybody. And we will be putting a Creative Commons license on this workshop, and it will be digitally available. So thank you, everybody. Thanks for coming. I'm going to stop the recording now. And I'm going to stick around, by the way. So if anyone wants to hang around and ask questions,